Hello, everyone. I'm talking about humanitarian and compassionate grounds application for permanent residence in Canada. And before we move further, please hit the like button if you have liked my previous videos, and do subscribe to my channel, as I will be sharing regularly about immigration applications for Canada, talking about categories and tips and problems which people face. And definitely subscribe and like my videos. Last time I shared some information, and today I will elaborate a little bit so that you get some more information as to how you can work on this if you have a situation like this. And first of all, I also want to add some more information that one is the humanitarian and compassionate grounds application. It's a full-fledged application that is under a public policy, and there is an application format to this. It has its own forms, and there is a special form that is IMM 5283 that is used from within Canada. It is a specific application for humanitarian and compassionate grounds application for permanent residence in Canada. But there are people who are overseas, foreign nationals, who are applying for permanent residence and do not fit into any of the, in one of the major, immigration categories, which is like family sponsorships, economic category, or refugee categories. So they can use those forms, the departmental forms of IRCC, when they're submitting their application, and provide written information in support of of their request for consideration under humanitarian and compassionate grounds. This again, like I said before, these applications, all considerations, the officer will definitely look at it. But from overseas, again, it is again at the discretion of the officer what he may consider. But definitely you can submit a request and they will look at it, see whether it really requires that your situation warrants, calls for that relief. So foreign nationals who are inadmissible and who do not meet the requirements of the acts or regulations for any particular category, they can request for this special consideration, right? As we have shared before as well. So, but there are certain people who will, there are restrictions on the applications too, and some of which I have discussed before in my previous video. And one has to note the onus is on the applicant, the person who is applying. He is fully responsible to prove to the officer. This is true for both, it will apply to both in Canada and overseas applications. And it is totally on the applicant to explain in his or their submission, to exactly explain what hardship, what circumstances, difficult circumstances they are going to face if they are not granted the requested exemption. So it is very important here that the onus is completely on the applicant. So they have to explain, and maybe of course they have to explain, and I would highly recommend gathering as much evidence documentation, if there are certain, proper documents, or if not, then you have people who have who can support your application, who can submit some support letter, or some information that will support your situation. Anything that you can do to support it. And there are other factors like what is the reasonable, or the, what is the threshold of proof? Like what is that you need to submit as a proof, right? So it is more likely that whatever your circumstances are, is it more likely than not that the evidence or information that has been presented is true, like it is on the balance of probabilities. There is a lower standard of proof, that is a reasonable ground to believe, can be used to assess inadmissibility. But again, all these elements of your situation will have to be determined by the officer, and they will use their own discretion to understand what is it. So they will look at the facts, they will see what are the inadmissibility points, factors that you have, and they will look at the standard of proof, like I said, was the balance of probabilities, that it is more likely than not that the evidence or information was presented is true. And then is there a reasonable ground to believe in your situation? Another factor that, if you're applying for permanent residence from outside Canada, again, you must request, you will have to request for this exemption, that this is the thing, this is the point where you do not meet the eligibility criteria. This is what is the situation you have done. You are submitting this application, but you need an exemption, and the officer will consider, deserving cases, and to process these applications. So one of the main factors, as I said in my previous video also, is the hardship. What is the hardship that the person who is the applicant, who is going to face, the applicant or his family? Like, why is it that is so important? The person needs to apply for permanent residence in Canada. And this applies to both the people, who are applying from within Canada or they are overseas. This is important. However, there is no hardship test as such, but yet the determination has to be made to justify the granting of an agency request. So it is an important consideration, while granting an exemption from a particular, particular act or regulation, and to grant permanent residence status to this person. Foreign nationals apply for permanent resident visa generally before entering Canada. So the decision maker would consider the extent to which the applicant, given their particular circumstances, would face, what hardship they will face, if they were not granted this relief. So the officer will also consider, because the person is outside Canada, first of all, and it is not a comparison, like the person is outside Canada, so one cannot really compare about his life or his settlement in Canada versus his life in the country of origin. But it is definitely an assessment of the hardship that would result if the applicant is not granted that exemption or a permanent resident visa. So, there are sometimes there are certain adverse country conditions that which would include factors having a direct, factors that will have a direct impact on the applicant, which these situations can be like natural disasters, unfair treatment of minorities. It could be something like war, or maybe some, widespread internal violence. I was saying that, to support the claim of an adverse country condition, the officer is also going to look at the possibility if, the person can be relocated in their country. If they were to be relocated in their country, and this can be handled, this can be eased out. So you have to consider all these points when you're submitting your application. And inadmissibility is another factor. We have discussed quite a bit of it in my previous videos. Definitely look at them. And we will again touch base in our future videos as well. And another important factor is the best interest of the child. So, very often, children are affected. If the parent or a family member is affected, the child is also directly or indirectly affected. So this could be, this child can be a Canadian or a foreign-born child. So definitely the relationship between the applicant and any child directly affected need not necessarily be that of parent and child, but it could be also be another relationship that is affected by the decision. When I'm talking about the decision, is the decision on the applicant's file, positive or negative. So, for example, a grandparent could be the primary caregiver who is affected by an immigration decision, and that could in turn affect the child as well. Very often children are, are either close, they are reliant on their caregiver, and grandparents are very often, their presence is very important. And, the information that is submitted in the application will rely on, in totality, most of it will be reliant on this factor, that how is it the person is being affected, the child is being affected by the decision. So you have to make sure that you are providing enough evidence and information that supports your application. It has to identify factors that what are the factors that are going to impact the child. Is it like a child, maybe he is not able to function properly, maybe he is not able to adjust properly without the grandparent. There could be many other, maybe he needs care and attention of in specific matters. So the factors that will be related, they will be related to the child's emotional, social, cultural, and physical welfare. And other things that will affect it'll mean that what is the age of the child, like how old is he, how much does he depend on the applicant, what is the interdependency between the child and the humanitarian and a compassionate ground applicant. What is the degree of establishment of the child in Canada, and what are the links of the child to the country in relationship to which the agency assessment is being considered. What are the conditions in that country? what will be the impact of the situation on this child? Are there any medical needs where the child needs a special care? So how does it impact the child's education in that country? What if the agency applicant is not granted the permanent residence? How will it impact the child's education? Has it got anything to do with the child's gender? So these are quite a few of important factors that need to be, really considered when you're submitting your application. You want to look at it give it a deep thought and assess your own situation. I would highly recommend. Sometimes people say, oh no, let us just do the HNC application. It will be considered. If the factors are not strong enough, if sometimes you may not even need, if you explain, probably you already fall under some category of application. Definitely speak to a professional about it, and you will be able to assess your situation better. Sometimes talking to a professional will help you to assess. So definitely consider that. There are certain other family members too, who are not directly related, in the sense that they have been there, whether they are related to you by blood or not. But there is a lot of dependence. There is a de facto family member, like either who is in Canada or who is, applying to immigrate. So again, one has to assess, the officer will assess whether what are the compelling reasons that will allow such a person to come to Canada. So what is the dependency between the de facto family member? So what is a de facto family member? These are family members who do not meet the regular definition of a family class member. They are in a situation of dependence that makes them a part of the nuclear family, that is either in Canada or again applying to immigrate, coming to Canada. It could be, an elderly relative as well, some aunt or uncle or an unrelated person who has always been with the family. Sometimes it just happens in many countries, a family member or somebody is all the time. Their very presence makes all the difference. They have been integral part of the family. So it could also be a son or daughter who is over the age of 19, so they were left alone in the country. It could be, so definitely discuss with a professional about it. And I look forward to talking to you more about these applications in my future videos. Thank you.